and the judges will begin.
Good morning. Welcome to the finals and congratulations for making it this far. My name is Tim Isaacs. I am the Executive Director for the Center for Teaching the Rule of Law at Roanoke College in Salem, Virginia. And I would ask my colleagues to introduce themselves.
Hello, everyone. My name is Darcy Kern. I am a professor of history at Southern Connecticut State University and also an alumna of the program.
My name is Jamie Gass. I'm director of the Center for School Reform at Pioneer Institute. It's a Boston-based think tank that does research on K-12 education reform.
And all you smiling faces, if you would introduce yourselves.
Good morning, everyone. We are Unit 1 from Team Indiana, Hamilton Southeastern High School. Our teacher and coach is Janet Chandler. Our assistant coach is Alana Kane. My name is Preston Reynolds. I'm the Unit 1 captain. I'm attending Wabash College in the fall with a double major in history and economics.
Hello, I'm Kai Rexroth. I will be attending Indiana University and I'll be majoring in accounting.
Good morning. My name is Meredith McKenzie. I'll be attending University of Massachusetts and majoring in history.
Hello, I'm Luke Jin. I'll be attending Indiana University and have an undecided major.
Thank you. Luke, if you could turn up your volume or get closer to your microphone. I'm having some difficulty hearing you. Thank you. All right, this is Unit 1, Question 2. Want to make sure everybody's on the same page. I'm going to read the question and the sub-questions, and then you will provide your responses. Parliament passed the Habeas Corpus Act of 1679. What is habeas corpus? And to what extent, if any, is it essential to the principle of limited government? How has the writ of habeas corpus evolved in the United States? Under what circumstances, if any, might the writ of habeas corpus place an unreasonable burden on the government? Timer, you may begin.
Sir Edward Coke, former Chief Justice of the King's Bench, stated,
The Great Charter of the Liberties of England, it is declared that no free man may be taken or imprisoned or be disseized of his liberties, but by the lawful judgment of his peers.
habeas corpus limits government to a great extent. Latin for you may have the body is one of the 5 prerogative writs of English law. The writ of habeas corpus is issued to bring a prisoner to court to determine whether or not the person is being held in custody lawfully.
Parliament enacted the Habeas Corpus Act of 1640, which established that those accused of crimes were able to request proof from their imprisonment before they were charged. This limited government and the king's power to a great extent by putting rights of individuals before the overall country.
Passage of the Habeas Corpus Act of 1679 further limited government. This act was passed during the reign of King Charles II, limiting his power, ensuring he could no longer arrest opponents, preventing imprisonment without a proper order from court.
Philosopher John Locke's ideas directly support limited government, as he believed the best way to protect the rights of the people was to restrain government power. Habeas corpus further limited government in an era where absolute monarchs controlled entire nations.
The transferal of the writ of habeas corpus from Great Britain to the United States highlighted a number of ideological and cultural differences over multiple centuries. The United States version of habeas corpus differed due to the suspension clause of the Constitution, placing the issuing of habeas corpus to all, only limited by time. When combined with the suspension clause, all detention should be legitimate and just.
The troublesome factor of the writ of habeas corpus concerns suspension due to threats to Americans. Habeas corpus was suspended multiple times in our history, such as under President Lincoln in the 1863 Habeas Corpus Suspension Act, during Reconstruction in 1871, the 1905 revolt in American-occupied Philippines, as well as habeas restrictions in the 1942 Japanese internment.
The Anti-Terrorism and Effective Death Penalty Act of 1996 expanded federal authority on detention. This was expanded following the 2001 attack on the World Trade Center and the subsequent declaration of the War on Terror.
The Supreme Court continues to defend the writ of habeas corpus in cases such as Hamdan v. Rumsfeld and Boumediene v. Bush, ruling that military commissions cannot supersede inalienable rights and that congressional discretion is required for action regarding unlawful detention. However, With the stagnation of habeas corpus in military facilities such as Guantanamo Bay, the writ of habeas corpus seems to be in the weakest position of its nearly 300 years of existence.
On the other hand, while the writ of habeas corpus and its rights provided to prisoners has at times been impeded, there is an argument that habeas corpus as it is now is costly to the government, particularly in terms of legal resources, time, and money. Because of the ease of submitting a case for habeas corpus and the expenses required to assess them, this contributes to a large drain on legal resources.
However, it can be argued that the writ of habeas corpus does not place any unreasonable burden on the government due to legislation aimed at preventing its invocation, as well as its capability of being suspended in extenuating circumstances. Following this logic, it seems that more of a burden is placed upon the prisoners themselves, as they must navigate complex legal structures, resulting in many failed habeas corpus cases.
The writ of habeas corpus is essential to protecting the right of prisoners and helps prevent abuse of governmental powers. Regardless of being a heavy burden on government, it is an essential right. In recalling its importance, the words of philosopher Edmund Burke must be considered.
The people never give up their liberties, but under some delusion.
This concludes our testimony. We are now ready for your questions.
Okay, Darcy, you want to go first?
Sure. Does the writ of habeas corpus under the Constitution only apply to U.S. citizens, or in the case of some of these events of the War on Terror, does it apply to non-U.S. citizens as well?
So currently, habeas corpus applies to citizens, non-citizen residents, and foreign tourists. So habeas corpus is kind of an all-encompassing right that is given to anyone who is on U.S. soil.
And to further that idea from my colleague, from the outcome of Rasul v. Bush, and this argued, and the decision was that all enemy combatants have the writ of habeas corpus, and they have the ability to submit a petition of habeas corpus in this case. Because before this decision, oftentimes, especially at Guantanamo Bay, these prisoners and enemy combatants had no habeas corpus rights because the government deemed them to be enemy combatants and not determined to have rights, or the writ of habeas corpus specifically.
Jamie?
When James Madison, the father of the Constitution, was president during the War of 1812, New Englanders threatened secession, and the British even burned the White House. Still, he never suspended habeas corpus or abridged domestic civil liberties. Why do you think President Madison showed so much constitutional restraint during wartime?
James Madison himself was one of our most moralistic presidents. While his presidency wasn't the most progressive, he had arguably some of the most progressive principles of all the founders. And during the War of 1812, while he did exercise certain powers which were overreaching of the executive, suspending habeas corpus was not one of them. He held in very high regard the words of Immanuel Kant on autonomy, whereas if you restrict the autonomy of the citizens, the only result can be revolt.
Going off of that, philosophers John Stuart Mill and John Locke would argue that the common good of the country would be preserve those rights. He would argue that despite the harm and the initial benefit that may come from suspending habeas corpus, setting a precedent of suspending during such circumstances would inevitably have dire consequences in the future.
Additionally, during the time of the war in 1812, the United States was still such a relatively new nation. If President Madison did issue a suspension of habeas corpus, that could prove detrimental to the United States at the time. As we argue, habeas corpus is probably one of the most essential rights to American citizens and citizens all around the world. I think if it was suspended during that time period, it would just have dire consequences for the US being such a young and new nation.
Okay. Is it ever justified for the government to try someone in absentia?
I wouldn't quite say it's justified. We have done it with justification before. The most primary justification would be wartime. We saw many tryings under absentia during the Civil War, particularly, but the Supreme Court has almost always overturned that kind of ruling. A similar case would be Ex parte Milligan, where while the defendant Milligan was tried by judicial hearing under a military commission, that was overruled by the Supreme Court eventually because they saw that as a harmful position for both the national judiciary and the state judiciary.
Furthermore,
Possible examples?
I'm sorry?
Other examples?
Another one would be ex parte Mulligan. It sounds very similar, but it is a different case. It occurred just across the border, and there were similar circumstances among it. However, the Supreme Court did do the same thing they did in Milligan. They overturned the military commission's decision, and they upheld the writ of habeas corpus, but that was only following the end of the Civil War. We saw that courts are a little more inactive during wartime, leaving a lot more power to the executive judicially.
Kai, did you want to add something? You started to speak.
yes, so with that idea of protecting habeas corpus, even though it goes with the idea of Italian philosopher Cesare Beccaria, especially in his essay on crimes and punishment, he argued that the rights of criminals or the rights of offenders matter just as much as the rights of the victims. Especially in this case, this was truly influential to the founders of this country, such as Thomas Jefferson and John Adams, because by showing that these rights, no matter the circumstance or no matter the time, especially even if they are a military prisoner or a military convict, their rights still matter because they're still a person, and the U.S. still must uphold these conducts, even if they deem it to be an extenuating circumstance.
Additionally, going off my colleague's thoughts, it could be argued from the perspective of John Locke that habeas corpus is a preservation of life and liberty, which John Locke mentions in his social contract is the rights, all essential rights to human beings are the preservation of life, liberty, and property. So it can be argued that habeas corpus is that essential right that needs to be preserved for all citizens.
However, philosophers such as Plato would argue that these rights are only able to be guaranteed when the government exists. And because of that, we should at times trot over them to preserve the government for the common good of advancing the rights of most people as possible.
Okay, thank you. Jamie or Darcy, did you have any other additional questions?
Sure. According to the U.S. Constitution, only Congress has the power to suspend habeas corpus. That is, the president does not have that authority to. Then why were presidents like Lincoln and Grant, FDR, and George W. Bush permitted to suspend habeas corpus?
Suspensions such as President Lincoln, often with that, the Civil War was divided Congress. There was not as many people to conduct the business because half of the Congress had seceded with the rest of the Confederacy. And with that idea, he felt that he had the power to do so because Congress wasn't in action. And by suspending habeas corpus through this manner, he showed that the executive did have power. But following the Civil War, especially into the presidency of Andrew Jackson, the Supreme Court did rule that this was unconstitutional and repealed the act that he passed in 1863.
Going off my colleague's thoughts from the thoughts of philosopher John Locke and his ideas, he was a big proponent of the doctrine of prerogative, which stated that it is an executive's duty to do maybe what the law doesn't explicitly say, such as suspension of habeas corpus, if it is to preserve the life of the country. So in that nature, Lincoln at the time thought that this would be best for the United States in such a divided time.
Additionally, restrictions seen in the modern day under George Bush were oftentimes preceded through laws instead of through a direct suspension of habeas corpus. And the Supreme Court had overturned many of those laws. The Effective Death Penalty Act, as well as the Military Commissions Act of 2006, were both overturned by the Supreme Court to be adapted later to give more habeas rights to certain prisoners. So even though there is this suspension in the modern day, there still is the Supreme Court's protection.
Okay. Perfect timing. Thank you. Well done. Jamie or Darcy, you want to start with your feedback?
Sure. First of all, I want to thank you and your teacher and your parents for all your hard work. It's difficult material. I liked in your introductory remarks how you kind of evenly divided your time between British law and some of the origins and philosophical foundations, as well as the more contemporary examples, or the examples from American history too, and Lincoln, Grant, FDR, George W. Bush, et cetera. But I like the way you organized your time in there and walked through Lincoln, Grant, FDR, Bush, with specific historical events. And, you know, it seemed like a common thread there is that these things are jeopardized during crisis or war, right? And I thought you were strong on that. I thought that your answer to my question about James Madison and drawing on some of the influences that Enlightenment thinking had on Madison, I thought was very plausible. I appreciated your reference to Cesare Beccaria, and Renaissance thinking. That certainly had a big impact on the founders. So you should be, pleased with your performance. It was very solid.
Yeah, this was excellent. You guys did a great job giving the English background to the writ of habeas corpus. You talked about Charles II. You talked about the 5 prerogative writs of English law. You even mentioned, once you got to the American version, you mentioned how it differs. You mentioned the Philippines and U.S. involvement in the Philippines, which I think is a precursor to some of what we see today. You gave Supreme Court cases. You gave perfectly reasonable explanations for why it's costly. I thought your answers to the follow-up questions were very good. Your answer to my question on whether this only applies to U.S. citizens or others was excellent. The philosophy, very specific Supreme Court cases, how to apply this to the modern era. This was just a very, very great presentation.
Yes, I was impressed with the breadth and depth of your resources, from the earliest British resources through Locke, John Stuart Mill, Plato, that you even mentioned Immanuel Kant, which is probably the first time I ever heard his name mentioned in any We the People competition. One of the suggestions I would make, and it's very minor, it has nothing to do with your content, the continuity of your responsiveness. There were sometimes little lapses when you were responding to the questions, and it wasn't because I don't think you didn't know the answer. You knew the answer, but it was sort of one of those thoughtful hesitations. And if you could be a little more responsive, I think there'd be a better flow for the entire presentation. But you certainly knew how to connect the past and the British to the present and the American, and that was very well done, seamlessly done. So good job and good luck the rest of the day. Any other questions, friends?
I think we just wanted to say thank you so much for your time this morning. Your feedback is definitely really helpful to us, and we really appreciate all of you coming out this morning.
Well, you're welcome.
Thank you all very much. The pausing thing has been a touch and go thing for a while on us, so getting that hammered in is always helpful.
Well, good luck.
Great. Congratulations to all.